Hello viewers, happy to meet you again. In this lecture, you will be learning what is meant by the term writ. What are the five types of writs? What is writ in law and constitution? What is the process of writ? Why do we need writ? And why it is considered as a constitutional remedy? For those questions, hope this lecture would be finest answer. So before learning those things in detail, I request you to subscribe our channel if you haven't subscribed yet, and please press the bell notification so that you could get those videos immediately and you will never ever miss the future lectures. So let us start the lecture today. So the first thing that you should learn is writs are remedies. So we consider this as a constitutional remedies. The other name for writ is also known as constitutional remedies. And the chairman of the drafting committee, Dr. B.R. Ambedkar, says the very soul of the constitution and the very heart of it. What is that? That is the constitutional remedy. We have given a lecture on constitutional remedies, the previous lecture. If you haven't watched that, please do watch so that you will get a better idea. The next one here is the right to the constitutional remedy was created as one of the main rights. So we have fundamental rights. Even though we have fundamental rights, in case an individual who is having problem in claiming or enjoying his liberty, he can use this writ and he can approach the Supreme Court or the High Court and he can establish his liberty or freedom. And in case it is being denied for any individual, if any of his or her fundamental rights are being denied or deprived, he can approach either the Supreme Court or the High Court. And we have fundamental rights. Before understanding the writs, you must understand the fundamental rights and its importance. For any citizen of this country, he got certain rights. We have rights to equality, freedom, exploitation, against exploitation, freedom of religion and cultural and educational rights. The last one comes the right to the constitutional remedies. That's what we are talking about in writs now. So the constitutional remedies, what is that? If it is denied either by the government or any official, you can approach the Supreme Court and High Court to establish your fundamental rights. So having an idea about the fundamental rights is a matter of fact over here. You should learn the fundamental rights first. So here we have given the most important rights. What is that? The important rights, the right to the constitutional remedies, that is called writ here. So the constitutional remedy, what do you mean by constitutional remedy? If an individual is being suppressed, or if the government, either the government or the officials, if they are denying any individual's freedom or rights being denied or deprived, that individual can approach. There is a solution for him or her to approach the Supreme Court or the High Court to seek justice and to establish his liberty or freedom. That's what we are talking over in the fundamental rights. So here, even though it is a fundamental rights, you have certain liberty to enjoy over in this country. You have certain restrictions during the emergency period. In the last lecture, we have given a clear picture about the emergency, either the presidential rule or the government or the governor's rule, if it is being implemented in the country or in the state where you cannot expect the government to give enough freedom because our country or our state is under emergency. In such situations, the fundamental rights can be stopped or it can be appended. The government has the flexibility to append the rights of the citizen. Why? Because we are under emergency. During that period, you cannot claim or you cannot seek any justification over there. It must be followed, it must be obeyed as a rule, as a constitution, as a citizen of this country. You must adopt or accept if it is a problem or if there is any emergency in your state or country. So, according to Article 32, Indian citizens can stand up and fight for their fundamental rights, but in during emergency, it is not possible. You cannot claim when the government announces that we are under emergency. There are three different emergencies. One is medical emergency. I think probably we had enough exposure to the medical emergency during the COVID lockdown. So during that period, you cannot say that I am going to establish my fundamental rights. So one is, the next one is war. During war or any such activities, you cannot claim. The third one is financial crisis. So financial emergency is one of the most worst emergency, and during that period, if the government announces financial emergency, you cannot claim that you should or the government must allow you to enjoy your liberty. So that is not possible, especially this applicable. What is applicable here? One is during the war and another one is during the medical emergency. So we cannot claim or we cannot approach the government or Supreme Court or High Court to allow you to act independently as you are the citizen of this country or you got enough fundamental rights to enjoy. So that is not possible, only during the emergency. That you must remember always. So here comes. So let us learn what is writ. As we already learned, writ is a remedy. A remedy for whom? A remedy for an individual to establish his or her fundamental rights. So every individual can enjoy his or her liberty, freedom, and we have fundamental rights to enjoy in this country as a citizen of this country. But in certain time, in certain period, it is not possible, that we have seen in the last slide. So here we would like to learn what the writ exactly means. What it means a written issue or an order. So a written issue from whom? From the court, either by the High Court or by the Supreme Court. It comes under seal. So there is a emblem which is being printed on that, and it comes with that. And in the name of a sovereign government, court or other authority commanding an officer or other person to whom it is issued to do or refrain from doing some act specified therein, you must obey. If the Supreme Court says, if the writ is being issued, there is no second opinion or there is no further delay. It must be done immediately. Especially for whom? One is for the government and another one is for the officials, government officials. So that you must remember. So writ is an order from the court. To whom? To the either to the government or to the authorities, government officials. For which is why it is being issued? To help the individual. If the individual's freedom, rights are being denied or deprived, it can be claimed or it can be regained through the Supreme Court or through the High Court. The next one, who can issue? See, the Supreme Court jurisdiction is lie down under Article 32 of the Constitution of India. So, the writ jurisdiction of the Supreme Court is, however, narrower than that of the High Courts. And the writ jurisdiction of the High Court. The High Court's jurisdiction is lie down under Article 226 of the Constitution of India. So, Supreme Court follows as per Article 32. It is for Supreme Court as per Article 226 High Court. And we have given the difference between the 32 and 226 in the previous video. If you haven't seen that, please do watch so that you may have a clear idea about that. And the main intention of the Constitution of India in respect of fundamental rights is to protect the individual from the arbitrary action of the state or others. As we already stated, it is very difficult for an individual to fight against the government or any officials in case his rights are being banned or buried or denied or deprived. So he can he can come through the Supreme Court, because the Supreme Court can order the government and the government must obey whatever the court says. And here writs can therefore be considered as an important instrument used by the aggrieved against the state or other violators. So this is very, very important over here. For any violators, if they are violating, an individual can very well approach the Supreme Court. And the next most important, we are again giving you the distinction between Article 32 and 226 briefly. So here Article 32 can be exercised for the enforcement of fundamental rights only. Do remember, the Supreme Court can exercise for the enforcement of fundamental rights alone using Article 32. According to High Court, this is but Article 226 can be exercised not only for the enforcement of fundamental rights but also for the enforcement of rights other than fundamental rights. Thus, the writ jurisdiction of the High Courts under Article 226 is wider than the writ jurisdiction of the Supreme Court under Article 32. So we have in a different aspect. So we are narrow downing when it comes to the Supreme Court, and it is very wide when we approach the Supreme Court. It is not the fundamental rights, any rights. So I can live, I can speak, I can learn, I can choose my religion. Likewise, anything that you enjoy under the shelter of this country, if it is being denied or deprived, you can very well reach the High Court where you have wider area. And here in Supreme Court, it is being zeroed down only for the fundamental rights. In case if it is denied or deprived, then only the Supreme Court can come into the picture. But whereas when we consider the High Court, it is totally different, where we can have for any rights. Sir, I can choose this or that, but they are telling me not to choose that. Anything like that, you can go and approach the High Court, and a solution will be immediately given. And as far as concerned, they are in our state. See, the High Court, which is very, very local, where you can approach immediately, whereas when we talk about the Supreme Court, it would be very, very difficult for you to approach, and getting justice from them will be you will be spending maximum time. Here it is time saving. When you approach the High Court, it is time saving, and economically that would benefit you a lot when you reach the High Court. And history of writs in India. So when it was issued and how, by whom it was issued. So the first issued by the Supreme Court of Calcutta. So there were three different Supreme Courts during the period of Britishers and East Company, and the first one was by the Calcutta Supreme Court of Calcutta, the later by the Bombay and Madras. So since 1861, the High Court started issuing the writs, and since 1937, and we have the Federal Courts of India that are issuing writs. So it's a short introduction about when we started, how we started, and now we have only one Supreme Court in our country, that is in Delhi. So kinds of writs. There are totally 5 different kinds, and that's what listed. One is habeas corpus, qua warranto, mandamus, and certiorari, and the last one is prohibition. So we are going to learn one by one in detail, and in what case such writs will be issued, or on what basis you can get issued such writs. That's what we are going to learn today. The most important one is the writ of habeas corpus. What do you mean by this? You have the body, you shall have the body. This is what the body, and this is that's a Latin phrase, Latin word, okay, which means you have the body, or we command that you have the body. That is the meaning. Okay, it means you have the body and produced it before the court. What is the purpose? To seek relief from the unlawful detention of him or herself or of any other person. If unlawfully, if the police, if the department, okay, so the police department, if they are detaining you under certain circumstances unlawfully, if you find it unlawful, you can approach the court. And the object of this writ is to release a person who is illegally detained. And according to law, no person shall be detained unlawfully. That is very, very important here. So the police cannot arrest you just like that. It must be proven, and there must be a strong background behind that purpose. Everything must be viewed, analyzed properly. After that, only they will take you under custody. In case if you find it is an unknown X or Y for no reason, if the police caught you, you can approach the court and you can protect the particular individual. So, but to protect the individual from harming him or herself or from being harmed by the administrative system. Here, administrative system, which means exactly to the police department. And here cannot be suspended even during emergency. Do remember this. Out of 5, we already seen during an emergency, the writs or establishing your fundamental rights may not be possible. But out of 4 writs, only 1 writ assures you that even during the emergency period, it can claim, you can use habeas corpus. It cannot be suspended during the emergency. Out of 5, 1, it talks even during the emergency, because detention for no reason, that is not legal. It is totally illegal according to the constitution. So it will speak even during emergency, that you must remember. And here we have certain conditions. We are going to talk about certain conditions. And apart from that, if a person who is arrested is not produced before the magistrate within 24 hours from the time of arrest, he will be entitled to be released on the writ of habeas corpus. Do remember, he or she must be produced within 24 hours in front of the magistrate. In case if they fail to do that, they can claim, approach, and get the writs issued by the either the High Court or Supreme Court. That is most important point that you must remember. So here we have something to learn in depth. One is, what are the condition and under which condition they issue this habeas corpus. As we already stated, there must be illegal detention of the person. If he or she is being taken away by the police department illegally, they can apply. Number two, the detention must be illegal at the time of filling the petition. That is very, very important. Number three, the detention must be unwarranted by law. Number four, he or she must be produced in front of the magistrate within 24 hours from the arrest. So, you can get the habeas corpus to protect you. Number two, who can apply for writ of habeas corpus? A person who has been detained illegally, he can or she can. A person himself whose detention is illegal, or any person on behalf of the detainee or prisoner. So, if X is being arrested, if X got a friend called Y can, on behalf of X, he can approach and he can apply for the writ of habeas corpus. So it is not the person who is being arrested. Instead, an X or Y, his friend or relative, can apply on behalf of the person who is being detained illegally. In case illegally, that is very important, illegally. And when writ of habeas corpus is not issued, number one, if the detention has been made in accordance with the law and procedure, if they have warrant, that's what very important. If it is being given, produced, you cannot apply for habeas corpus. Number two, where the person against whom the writ is issued or the person who is detained is not within the jurisdiction of the court. So, I belong to a state, and if I am being arrested and if I am approaching in some other court, if where I am not the citizen of that particular city or state, I cannot apply for the habeas corpus, which means the court will never issue habeas corpus. It must be under the radius. You must be the resident of that particular area. Number three, if a person who has been imprisoned by a court of law on a criminal charge, so if you are already accused and if you are detained and if you are a prisoner for a criminal activity, then you cannot go for, because you have been already proven that you have certain criminal activities, you involved in criminal activities. Number four, if the proceedings interfere with the proceedings of the contempt by a court of record or by the parliament, if contempt of act, if the court has already warned you in certain cases in certain period, the court will never ever issue habeas corpus for that particular person. So where you cannot climb or you cannot approach the High Court or the Supreme Court. The next one, mandamus. So what it means? We means mandamus. It's writs. It is also derived from the Latin word which means we command or sometimes we mandate, and is the name of the prerogative writ in the common law. and by why it is issued by a superior court to compel a lower court or a government officer to perform mandatory or purely misindustrial duties correctly. So remember, it is a guideline where the court, the higher court, will guide the lower court, subordinative courts, or any other government official to perform something mandatorily, where in case if they have failed, it will be issued as a warning. And it is an order from superior court. So the superior court is only one we have, and for the subordinative courts, it is being always the high court. So the high court, either the high court or the supreme court, can order any government, subordinative courts, corporation or public authority to do or forbear from doing some specific act which disturbs or which creates a problem among the citizens of that particular area or state. So in case they have failed to complete their activities, their duties, they must do, and for which the mandamus is being issued. So it's an order. What it means, it means an order. Mandamus is an order by Supreme Court or High Court, that you must remember. It is against the persons or authorities who fail to perform their mandatory duties, that you must remember. And the applicants of this writ must also have right to compel the performance of some duties cast upon the authority. In case, so if any of the minister, or if any of the councillor, or if the mayors, or if the officials, in case if they fail to perform properly, you can approach the court and you can talk through the court to those officials in a wiser tone to command them to complete those activities on time, and the court will condemn for not doing such activities on time. That you have to remember. And here, and what conditions the mandamus will be issued, the writ of mandamus will be issued. Number one, there must be public duty upon the respondent. So it must be a public duty, which means it must be helping, or it may be disturbing someone or the group of people. If it is so, you will be claiming for the writ of mandamus. Then the petitioner must have legal rights to compel the performance of public duty. In case if they have failed, if the official, if the government, if they have failed to complete that, which means to fulfill the activities or the duty, you can apply. And such duty must be mandatory duty cast by law. It is a what do you mean by that? Mandatory. It is mandatory. So supply of water, supply of food, shelter, and medical protection, everything comes under mandatory. During flood, during emergency, or during natural disaster, the government should protect the people. In case if they fail in doing so, you can approach the court and you can talk to the government officials through the court. And the next one is, the public authority must have failed to perform or refuse to perform the public duty. In case if they say, or if they deny. So for example, if the person one who is collecting garbage from your area, if they are not collecting, or if they are refusing to collect, or if the EB person who is denying, refusing to give connection to you, or if the person, the counselor who is not ready to help you in laying a proper road or street lights, that is denying his duty. Okay, it is mandatory. The requirement must be fulfilled. In case if they fail to do so, you can prove. The next one is, against whom the mandamus is issued. Number one, against public authorities and institution departments. Number two, against officers exercising public functions, that is, the public authorities, any government officials you can put under the tree, against government and public corporations. So it comes under government officials, the institutions, the departments, whatever it may be. In case if they fail to do their duties, the mandatory duties, mandamus will be issued. And when writ of mandamus is not issued, number one, when the duty is merely disciplinary in nature, it's just, it is for namesake if you are complaining, or if it is not their duty, then it is not issued. Writ of mandamus cannot be issued against private individuals or private organizations. It is purely governmental. Number three, writ of mandamus cannot be granted to enforce a duty rising out of contract, on contract basis. So if it is under contract, for the contract basis work, you cannot go approach mandamus. It is a routine mandatory duty. For collecting garbage is mandatory duty. Fixing the lines properly is a mandatory duty. During emergency, during natural disaster, protecting people is mandatory duty. It is not contract basis, during which if the government or official fails, you can approach them and get the justice through the High Court or Supreme Court. And the next one comes the writ of certiorari. Here, what it means, which means to search. What is the meaning of certiorari? Which means it's a Latin derivative word, and which means to search. And it is an order by a Supreme Court or the High Court to the inferior courts to remove a suit from such inferior court or adjustment upon the validity of the proceedings, or squash the order of the inferior court. I think probably squashing. What do you mean by squashing? Telling the people that you have accused someone wrongly. It is purely intentional, or you don't have any background, which means there is no proof or evidence properly produced. This case is only to defame someone. If the court thinks as such, say the certiorari will be issued. Do remember, the court will be squashing the case. Squashing, which means cancelling, closing that case and giving a warning to the petitioner who has given the case against X or Y. So most of time, it happens over in Tamil Nadu, especially at the present situation. Most of the cases are being squashed, which means wantedly to defame someone. Either the government or the government authorities or the political party members are giving complaint on some X or Y, and the X or Y are ready to prove that the information were given wrongly either by the government or officials or the political parties members. So in certain period it will be taken as such. And what this exactly means? Currently means an order by an high court directing the lower court or public authority to send the record in the given case for a review. What you have done is wrong. It must be interpreted in a different way, in the some other perspective. So make sure your judgment is correct. As like the High Court or Supreme Court will be asking or ordering the lower courts, the subordinative courts, to take care. And here we have a lot of questions to be answered. In what cases the certiorari will be issued? Number one, there must be want or excess of jurisdiction Number two, principles of natural justice must be violated. Number three, there must be an error of law on the face of judicial record in such a way the conditions it will be issued. Number two, when can a writ of certiorari be invoked or granted? Do remember, as we already stated, you have to produce proper evidence, proper ideas in front of the court. In case if the court finds this is not enough sufficient, or it is just of all fabricated stories, it will be squashed, as we already seen. And here, number one, before the trial, to prevent an excess or abuse of jurisdiction and remove the case for trial to the higher courts, that it will be stopped. Number two, after trial, to squash an order which has been made without jurisdiction or in violation of the principles of natural justice. So in a different way, if you want to learn, whenever anybody of persons having legal authority to determine questions affecting the rights of subjects and having the duty of act judicially, writ of certiorari can be granted. Number three, who can apply for writ of certiorari? Number one, any person whose fundamental right is violated can apply. As like other writs, you can apply for this as well in case of depriving or denying your fundamental rights. Number four, against whom writ of certiorari is issued? Number one, inferior courts and a body exercising judicial as quasi-judicial functions. So quasi-judicial, quasi-government, which you will be learning in the future lectures. So inferior courts, any subordinative courts, or the any governmental body, which means the judicial body, are quasi-judicial functions. And the fifth one is against whom writ of certiorari can be issued. Number one, against a private individual or body of private persons, it can be issued. Number six, when a writ of certiorari can be granted. Number one, to remove ministerial acts. Number two, to remove or cancel executive acts. Number three, to declare an act as unconstitutional or void. So this is very important, and in most of the cases, most of the individuals, if you talk against something, the government may file a case, or they fabricate a case and put you in jail. In certain cases, you can apply, and if the judgment given by the subordinative courts are wrong, or if it is being influenced in certain ways, if you find it so, you can approach the High Court or the Supreme Court, where the High Court or Supreme Court will ask the subordinative courts to squash the case, or they will direct the subordinative courts on how it has to be handled. So for which this writ is being issued. The next one is the writ of prohibition, the most important writ. So the prohibition is to prevent or stop doing or continuing an activity or action. So what is that? A legal document drafted and issued by a Supreme Court or Superior Court to a judge presiding over a suit in an inferior court, which means each court is expected to act within the limits of their jurisdiction. Okay, so they have their own limits. They cannot cross their limits. In case if they cross their limit, and if their jurisdictionary bound is being taken much more, immediately the prohibition will be issued, or you can claim for the prohibition. here. So the writs of prohibition can be issued not only against the courts but also against the authorities exercising judicial or quasi judicial functions. That is also very important here. So here it is used to prevent an inferior court from exceeding its jurisdiction or acting contrary to the rules of natural justice. As we always say, the defenders, the protectors of the constitution, that is the Supreme Court, will help the other courts to learn their jurisdictionary limits, and they will guide them in case if they fail to complete their activities correctly. Here we have to learn some of three questions. Who can apply for the writ of prohibition? Number one, a person whose right is violated can apply for the writ of prohibition. What type of rights? Any fundamental right, as we already seen for all five writs. One is very common: when your fundamental rights are being deprived or denied, you can apply. Number two, when can a writ of prohibition be granted? This is very important. When the inferior court or quasi judicial authority exceeds its jurisdiction, which means they cannot do certain, which means their powers are limited. It is not the power which is given to the Supreme Court or to the High Court. The subordinate courts powers are limited. So we have civil and likewise certain limitations are given to the courts for the subordinate courts. In case if they exceed, then this prohibition will be issued. Number two, when the inferior court acts without lawful jurisdiction. This is very, very important. So as I already stated, most of the subordinate courts, they just grant, in case if they grant, immediately either the High Court or Supreme Court can interfere, can cancel the case, and they will take over those cases and they will give justice to the affected person. In case if the Supreme Court or High Court finds the judgment which is given wrongly or against the Constitution, it will be immediately cancelled and the case will be only handled by the Supreme Court or the High Court. The next one is when the inferior court or quasi-judicial authority acts against the rule of natural justice. That's what we have explained in detail. And when there is an apparent error on the face of the judicial record, so against the law or against the Constitution, where comes in the hands of the High Court or Supreme Court. Number three, when is the writ of prohibition is not issued? Number one, when the court acts within its lawful jurisdiction, when it is always right, or when they maintain their limit, and if it is granted, either the High Court or Supreme Court cannot interfere. Number two, when the court observes principles of natural justice, when they follow the constitutional law, the High Court or the Supreme Court cannot interfere, where you cannot apply for prohibition. The next most important writ is qua warranto. What it means? What is your authority, or by what warrant? It is derived from Latin term, and it is an order questioning the authority of a person holding a public office, or requires a person to whom it is directed to show what authority he has for exercising some rights or power he claims to hold. And here the object of this writ is to control the executive action in making appointments to the public offices and to protect the public from the aspirants of public offices. So it is to invoke in cases of public office. So the public officials or the offices, if they fail to do certain, it will be issued quo warranto. Next one, we are going to learn what condition it will be issued. Number one, the office must be a public office, which means the governmental office. Number two, the office must be substantive in character with independent title. Number three, the respondent must not be illegally qualified to hold the public office. This is very important. Most of the cases today, you could see they submit a fake certificate. With the fake certificates they are claiming, and they are traveling, or most of them have been traveling since years, and if it is so, they cannot. And the respondent must have held the office against the law. So if it is against the law, if he is not qualified, or if he is proven is not qualified, or if he is being having illegal activities, or if he is not a citizen of the city or country, whatever it may be, by which it will be enforced. And who can file writ of quo warranto? Number one, any member of the public can file the writ of quo warranto, whether any right of such person has been enforced or not. So it is the public. If a public who is finding he is not capable, or he is appointed unknowingly or illegally, you can file a complaint and you can question through the court. And third one, when writ of quo warranto is not issued. Number one, when the office is not a private office. As we already stated, any writ will be issued only in the case of government office, or government officials, or the government. When the holder of the office is qualified to hold that office, so basic qualification requirement, if it is basic qualification, and if he or she is having the proper qualification, you cannot use this writ. Number three, when the holder subsequently gets qualified for the office, absolutely you cannot claim. Number four, the issue of writ becomes fertile. It means if the writ does not serve any purpose. That is also very important here. So in such a way is the writ that helps in establishing your rights and questioning the government or questioning the officials. So through which what you should learn, very simple, the government being the powerful department cannot suppress any individual. So whether he is rich or poor, that doesn't matter. If he is an individual, and if he cannot raise his voice against the activities or illegal activities of the government or the government officials or government offices, it can be used. Writ can be used. Writ that supports any individual, writ that supports any poor, which doesn't mean basically economically, which means inferior person can also go approach the court and get his justice. So here the Supreme Court as well as the High Court, they make sure that the fundamental rights of any person, any individual is not either deprived or denied. So you must enjoy. It is the constitutional idea. It is the idea of every individual. So we must enjoy our stay over here, and we have the fullest rights to question the government. And in case if the government fails to fulfill your expectations, you can approach the government. It is not only the government, it is the entire tree: government officials and government offices, whomever it may be, offices including, so it can be the corporation, great corporation, or municipality, or Nagar Panchayat, whatever it may be. In any case, the president, the councillor, the mayor, the cabinet ministers, whomever it may be, in case if they are not abiding the rule or if not following the constitutional ideas, any individual can get in touch with the court and get his or her grievances or problems solved through two means. One is the High Court as well as the Supreme Court. Hope you might have enjoyed this video. I will meet you in the next video with a fantastic topic. Do subscribe, do share this video with your loved ones. Thank you. Bye. See you again.